Case number 116981, State of Kansas v. Brandon A. Dannenbaum. All right, counsel, you may proceed.
My argument's been known to clear a room, but that was ridiculous.
Don't take it personally, counsel.
I apologize, Your Honor.
No, I was just going to say, for those who are watching at remote locations, we have taken an extra minute to let the spectators clear the courtroom so counsel are not distracted by any noise or movement. You may proceed.
Thank you, Your Honor. Please the court. Donald Lee Anderson, Owen, Kansas, appears on behalf of Brandon Dannenbaum. I would request 3 minutes of rebuttal time.
3 minutes is granted.
Thank you, Your Honor. A brief background of this case. This is a distribution of methamphetamine case out of Barton County, Kansas. Mr. Dannenbaum had filed a motion to suppress a search of his friend's apartment where the methamphetamine was found and was attributed to him being the owner. This court originally had basically, the state had followed that with a motion to dismiss the defendant's motion to suppress based on a lack of standing. At an initial hearing on that, the district court granted the state's motion to dismiss the defendant's motion to suppress. The defendant then filed a motion to reconsider, and argument was heard on that. The district court then reversed its own ruling, finding that the defendant did in fact have standing, and ultimately granting the motion to suppress. State filed an interlocutory appeal, which brought us before the Court of Appeals. The Court of Appeals then found that Mr. Dannenbaum did not have standing as a social guest in his friend's apartment to bring the motion to suppress, and subsequently Mr. Dannenbaum filed a petition for review, which this court granted, and we're here today. As stated, Your Honor, the issue that we're before the court today is on whether or not Mr. Dannenbaum had standing as a social guest in his friend's apartment. The Court of Appeals spoke about a sliding spectrum for social guests in having standing. On the far end, you had Minnesota v. Carter, where the person was legitimately on the premises, though it was there strictly for a commercial enterprise, and they found that man did not have standing to bring a motion to suppress. On the far end, you have Minnesota v. Olson, United States Supreme Court case as well, where the United States Supreme Court held that an overnight guest does have standing to bring a motion to suppress as a guest in the home. Basically, they put themselves in the shoes of the homeowner and allow them to bring forth that type of motion based on standing, because they want the person that's a guest of the home to be able to have the same rights and the Fourth Amendment protections as the actual homeowner. So that brings us to our case, which Mr. Dannenbaum is somewhere in between. He certainly, I think all the testimony from the tenant of the apartment, Ms. Tracy, and Mr. Dannenbaum himself, even the testimony of what the officers knew, is that Mr. Dannenbaum was at that Ms. Tracy's apartment on a regular basis. The testimony from Ms. Tracy and Mr. Dannenbaum was that he was there every day that summer, that this occurred back in June of 2014 or 15, I believe. The issue that the court, that originally caused the district court problems, and then what really seems to be the Court of Appeals issue, is that Mr. Dannenbaum was not present at the time of the search, and that his that he didn't portray a legitimate expectation of privacy in the home that was sufficient enough to overcome the fact that he wasn't present in the home when the search occurred. However, to that effect, a lot of what Mr. Donenbaum discussed in his petition for review was there was a lot of dispositive facts that the Court of Appeals relied on that lended themselves to where their ultimate decision, but there was also a lot of facts that spoke directly opposite of that just seemed to be disregarded because they weren't ever discussed. The Court of Appeals.
Let me ask about that real quick, because I think I read this differently, so I'm going to let you correct me. I didn't read that the Court of Appeals resolved any facts in dispute one way or the other. It didn't seem to me the facts were terribly in dispute. Now, how you analyze those facts under the law is a whole different question here. But I guess what I'm asking, is there really any factual dispute that the district court resolved in your favor that the Court of Appeals looked at differently?
No, Your Honor. I don't believe there's to be any factual dispute that the district court made any findings of fact. I mean, this is one of the cases where there's not a whole lot of findings of facts made at the district court. However, in the both parties' briefs, where the facts were laid out, I believe them to be pretty substantially similar. Where Mr. Donenbaum takes issue and what was argued in the petition to review to this court was, for example, one of the things the Court of Appeals addressed was the fact that Mr. Donenbaum didn't take any precautions to secure his belongings in the safe. The fact that Ms. Tracy stated that she believed the pen was somewhere around the safe, that the safe was sometimes left open, and that the safe wasn't concealed or hidden in any way, that it was used as a TV stand. However, they don't address or speak to the fact that the safe was locked when the police officers seized it. And not only was it locked, the officer actually had to take the safe and manipulate it, turn the safe around so the dog could sniff the seal of the door. That was in order for the dog to indicate. I mean, we don't even get into the second issue of whether or not the search was illegal, because the Court of Appeals found there was no standing that ended there. So I don't want to really waste any of my time on that, obviously. But and that's one of many points that I bring up in my petition review is that the Court of Appeals garners pulls from the facts that, again, are not really in dispute whatsoever, but they use the ones that I mean, it makes sense. It goes to reason. They use the facts that supported their ultimate conclusion, but it just seems that they completely disregarded the facts that are dispositive to where they got. Meaning, as I said, there was several additional facts about the safe, that it was turned against the wall, so the door was actually against the wall, TV on top of it. It was locked, and the fact that Ms. Tracy said that she believed the pen was around there somewhere. And she believed that Mr. Donenbaum didn't have the key, and she believed that, or Mr. Donenbaum said he believed he didn't ever stay the full night there, but the flip side of that, Ms. Tracy said that he did stay a full night on a few occasions, and it was a repeated theme of the Court of Appeals' opinion that the facts that worked against Mr. Donenbaum that had counterparts were never addressed. It was just the facts that worked against him. That was.
Isn't this the safe that the police knew so well that when they got it into the station, they already knew the combination? They didn't have to crack it open. They just
Yes, Your Honor.
They had it.
They actually had the pen at the sheriff's department. That is true.
Counsel, how would you define the property which you allege your client had a reasonable expectation of privacy in?
As far as the safe,
my understanding is that you argue your client had a reasonable expectation of privacy in the apartment.
Yes.
And that gives him standing.
Yes, Your Honor.
And so, given that, I'm wondering if that's not the wrong question to ask. Why isn't the question whether or not your client had a reasonable expectation of privacy in the apartment owner's bedroom? Because, and I asked the question because it seems reasonable to me to think that a social guest might have a reasonable expectation of privacy in certain areas of a home, common areas, and maybe a guest bedroom, let's say. It would depend on the facts. But not have a reasonable expectation of privacy in, for example, the owner of the home's bedroom. And so I'm just wondering if we're missing asking the right questions here.
This is the first that neither district court of appeals
Yeah, I realize that.
argued that issue, and I admittedly I will tell the court that I think it's a brilliant question and a very good point that probably should have been addressed prior to this.
But that also brings up, is the expectation of privacy against the homeowner that allows you to be a cohabitant, or is it against the public or other people? In other words, the whole premise of you're an overnight guest makes you have an expectation of privacy, but not necessarily from privacy from your host. Correct?
Yes, yeah, I would agree with that.
Well, let's just make a hypothetical in the extreme. Let's say you have a case that the facts are absolutely clear. You're a social guest. You stay overnight all the time. You have very close ties to the residence. But the search that takes place is of the homeowner's purse, let's say. It would be difficult for a person who was a guest to say, oh, I had a reasonable expectation of privacy in my host's, purse, let's say, or wallet.
And I would certainly agree with you there, Your Honor. The difference here in this case, small town, small community. I know this apartment complex. It's in my hometown. I know this apartment complex. So I don't want to get off on a tangent arguing things that aren't facts before the court, but it's basically just one room that's bedroom, or I mean there are some walls and whatnot, but it's all very small apartment. But what I would argue to that though is that he placed the safe in that room, in that bedroom. He was allowed to go in and out of her bedroom to access that safe. So I think that it goes beyond just it being kind of your initial question presented, Your Honor, that you would have that a social guest or even overnight guest would have a reasonable expectation of privacy in the common areas or a guest bedroom.
Your argument is that even if I'm correct, that the right question is whether he had a reasonable expectation of privacy in the bedroom. The facts of this case demonstrate that, in fact, he did have such an expectation in the bedroom.
That would be my argument, yes, Your Honor.
At least as to the safe he put there. I mean, he whether he slept there or not is irrelevant.
And that is spend a little bit of time on that issue. I mean, it's.
I'm talking about sleeping in the bedroom.
No,
as opposed
no,
to
I
the
don't.
apartment.
Yeah, I don't.
He napped in the apartment.
Yeah, and that would have been on the couch, is what the testimony was. Not that I would admittedly, unless I'm mistaken, there was never any testimony that he slept in the bedroom.
I just think the implication of the line of questioning was that a bedroom of the host might still be basically off limits to a social guest who sleeps in another room or has access to the rest of an apartment.
Yes, and
But that's just not an issue here. He didn't sleep in the bedroom, but he kept a safe there.
and that's I agree with that analysis of other justices' question where they went with that, is that even if there was a bright line rule that you had no expectation of privacy in the host's bedroom, well, if the host opens that bedroom to you and allows you access to it, I think that you overcome that problem.
Yeah. Thank you.
Could we get back to just the Court of Appeals and what you believe where they went wrong? And I think what they said was that because he was not present at the time of the search, then there was reasoning that he was not a current guest. Is that how you see their ultimate conclusion? And why is that wrong, or just tell us why that's wrong?
And I think that was the linchpin of the entire district court's decision. What was spent. Honestly, I mistakenly spent more time on the on the legality of the search in my actual brief to the court than I did on the standing issue, because I didn't believe it to be that blatant of an issue. I was quite shocked, to be perfectly honest, and probably shouldn't have been, that Court of Appeals ended the case on that issue. So, and I apologize for kind of going off on a tangent there.
Oh, no, we led you that way.
But
just get back to what they did.
My argument, and really what I thought was the linchpin issue of the whole standing for Mr. Donenbaum, was the fact that he was not present. The court took that into consideration. Even one of the things that I argued in my brief was that they presented in their unpublished opinion, I think 4 or 5 different state opinions as persuasive authority, where there literally was. Admittedly, I didn't go back and read these cases, but they, in the Court of Appeals opinion, their cite or their reference to the case had something to do with the fact that the defendant in those cases was not present, and they cite that as a persuasive authority, certainly. However, as far as the Supreme Court cases, in the United States Supreme Court cases, the 10th Circuit, our presidential authority here, there's a lot of the cases that say that when you read the facts and you talk, and it goes either way, the defendant was actually on the premises when everything occurred, but there's never any discussion of whether or not that point mattered. The only case, and of course, just because I couldn't find one doesn't mean it doesn't exist in either for or against me, but the only case that I could find with presidential value that was remotely helpful, I guess, or even dispositive one way or the other, was this court's opinion in State v. Huff, 278 Can 214. I believe it was a 2004 case. I didn't write the date in my notes, but I'm pretty sure it was a 2004 case where officers were called to an apartment based on a noise complaint. There were several social guests there. The guests were allowed to leave, and then a search was ultimately conducted after the search left. The defendant in that case, Huff, then later came back. Paraphernalia, drugs were found. Prosecution ensued. Huff came back later and said that, hey, that search was illegal, and obviously Huff was allowed to leave before the search occurred, and that had no bearing. I mean, really, if this court were to come to some type of conclusion that the Court of Appeals was right because Mr. Donenbaum wasn't present, then law enforcement officers are smart. They see where they get bashed from the Court of Appeals, from the Kansas Supreme Court, U.S. Supreme Court, and they train themselves better to not make those mistakes anymore. Alternatively, when these things happen, they also figure out ways that they can stay legal. And Rodriguez is a great example with the drug dog, where now we have local law enforcement that the drug dog just follows around the patrol officer, and when he pulls somebody over, he just runs the drug dog, not extending the stop. That's the same thing here. If this court is willing to say that you have to be present to have a expectation of privacy, to have standing, then law enforcement is just going to have every social guest leave before they search. Oh, they weren't present. They can't fight this. And to that point, one of the other, to wrap up real quick, I'm sure I've gone way over. One of the other things that I argued in my petition that I thought was really worth mentioning again was basically what Minnesota v. Minnesota v. Olson really stands for, is that the social guest is allowed to stand in the shoes of the host, and they're allowed to assert that that Fourth Amendment right, and that they have reasonable expectation of privacy. So really, if we're saying that the defendant's actual presence in the home is dependent on whether or not he has standing, then what we're really getting back to is saying that as a social guest, you're asserting that homeowner's right, Fourth Amendment right to their home, their castle. What you're really saying then is that a homeowner would have to be home every time there's a search in order to say that they had standing. And I don't think that's what the Fourth Amendment says whatsoever. I don't think that's somewhere we're ever ready to go.
Very well. Thank you, counsel.
Thank you for allowing the extra time to surmise.
Chief Justice, Justices, may it please the court. My name is Doug Matthews. I'm an assistant county attorney for Barton County, Kansas. My thanks to Justices Johnson and Stiegel. I was only going to mention the second issue that we had when we filed our brief in this case, but because of the questions they asked, I will start there. What we are talking about is an apartment that was being rented by a third person, Alexis Tracy. She is a friend of the defendant. But on the date in question, the 23rd of June 2015, she and her newborn child were the only individuals who actually lived at that apartment. When officers approached her on the evening of June 23rd, they asked her for consent to search the apartment. We're looking for Mr. Dannenbaum. We have a warrant for his arrest. May we search your apartment? Her response was yes.
For
Now,
the
she was
purpose of looking for Mr. Dannenbaum.
The officers indicated that they were looking for him, but they also asked if they had consent to search. Now, somewhere in the conversations that she had with the officers who were there, she also noticed that one of them had a dog with them. Now, the dog was the canine partner of a sheriff's deputy. The deputy's testimony was that he would take the dog in, the dog would respond to a command to look for someone, and if they found the individual, they would place him under arrest. They didn't do that, but before they actually went in, Miss Tracy told them, if the dog goes in, you're going to find the stuff, or words to that effect. I'm paraphrasing what she said. And when she's asked, she answers specifically, yes, drugs. You're going to find drugs. So she has not only consented to an entry into the apartment, but now the officers had a reliable source of information telling them.
Counselor, I guess I misunderstood. I thought the posture of this case right now is not on the merits of the legality of the search, but whether this defendant even had standing to challenge the search. Am I wrong?
You are not wrong, sir. However,
So the question is whether Mr. Dannenbaum had a reasonable expectation of privacy in his locked safe that was in Ms. Tracy's apartment. Isn't that really the bottom line question for us today?
that is the bottom line question. However, when we prepared our brief, we didn't know that that was the only issue the Court of Appeals was going to take up. The officers had consent to enter. Mr. Dannenbaum's privacy rights in that apartment do not overcome the consent of the owner.
That's not before us, though.
It is not, but it is something that must be remembered.
Why? Why does that matter one bit?
Because if we're going to indicate that the defendant has standing, the next question we want to ask is...
I understand that's the next question, but we don't bias or even consider merits when we ask the question whether a party simply has standing to be heard, do we?
If we're going to look strictly at the standing question, no.
Okay. So it doesn't need to be kept in mind then. The outcome of the merits really doesn't have anything to do with the question before us.
In that event, sir, Mr. Dannenbaum still doesn't have standing.
So why don't you turn to that argument?
I want to ask a little bit about the importance of presence, which apparently was compelling for the Court of Appeals. It would seem to me that a person uses a locked safe in order to safeguard their property when they're not present. That's the whole purpose of using a locked, limited access vessel in which to put your stuff, isn't it?
One would assume so, yes.
Well, why doesn't that give an expectation of privacy if you have secured it against anyone else's entry? If I have a locker at the country club and I put a lock on it, don't I have an expectation of privacy in that place? Or
Well, you do, and society would expect that in order to gain entry into that locker or that safe, you would go back to a magistrate or a judge and request authorization to enter, which is what happened in this case.
But it was the seizing of the safe that's at issue, whether he has standing to challenge the seizure of it.
Again, I don't believe that he does.
But just if I could clarify, because that's my confusion, I think, as well. It goes to Justice Byers' question. My understanding is the defendant is challenging the search of the bedroom, not the search of the safe. And those are two different things, right?
If we're talking about the search of the overall property, then yes.
Well, it's the search of the bedroom that matters, right? Because that's when everything started happening
Yes.
that put the defendant in the position he's in now. And so the reason that matters is because it changes the question of that we're asking as to his expectation of privacy. Whether he had an expectation of privacy in the inside of the safe is not really the right question, is it? It's whether he had an expectation of privacy in either the apartment as a whole or the bedroom specifically. Isn't that the right question?
It is the question, and to answer that question, I respond thusly. He did not have a privacy interest in the apartment. His contacts with Ms. Tracy were definitely there, but again, he was not present on the date of the search.
Presence can't be the determining factor, can it? I mean, maybe it's a factor, but it
It
can't
is
be
a factor to be
determinative.
considered in the totality of the circumstances.
It seems to me as if the Court of Appeals treated that as almost kind of a king's X factor. Like, once we find that he wasn't present, that's the end of the inquiry.
Well, that was the factor that they ultimately made their decision on, but they considered everything else that they had available to them. We know that Mr. Dannenbaum was in the apartment on various occasions. We know that on at least 2 occasions, he was in the bedroom, once to put the safe there, and on the 23rd of June in the morning to put something into the safe.
And he slept at the apartment on numerous occasions.
He slept there for a few hours at a time, but never overnight, and we don't know that he was ever actually in this master bedroom.
But he had access to the apartment. He was basically someone who the owner had given permission to come and go. Is that a fair assessment?
Not quite. He had permission to be there when she was there. He did not have a key to the apartment, so he wasn't free to enter or leave whenever he desired to do so if she wasn't there. And there were times when she was there, he never actually went in to the apartment. So although he had access to the apartment when she was there, the opposite isn't true.
But he had, not only this safe, he had other property there. He had some clothes there and some other property. And
On the 23rd of June, when he brought this package by, which later turned out to be about a pound of methamphetamine, he also brought a duffel bag and some clothes that were in the duffel bag. The drugs, we believe, were carried in a blue cooler.
But he had other property that Ms. Tracy had allowed him to leave at her apartment.
If that's the property we're talking about, yes.
Okay.
My reading of the record doesn't tell me about any other property. We know that he took clothes there and this cooler. on the morning of the 23rd of June. But that's the only time we know of where he actually left something other than the drugs in the apartment. So although
And
she,
this was the date of the search?
yes,
And so, what's your point with that? If on the date of the search, he took property there, a duffel bag that had clothes, and he left it at the apartment, and apparently it had at least implicit consent of the owner to leave that stuff there, then why doesn't that cut against you? That on that date, he most certainly had an expectation of privacy because the owner was letting him leave his stuff there.
on that day, yes, but that doesn't establish any kind of long-term relationship or status that allows him to do that. If we had been talking about some day in April or May or earlier than that, where he left something at the apartment, then his ties to her would definitely be stronger.
Well, you
Why
did
doesn't-
say, as I understand it, that we know he went to the apartment on at least 2 occasions. The first time was to put the safe there, and the second time was to put something else there, and that would have been June 23rd.
Correct.
Correct?
Yes.
So he took his personal property, his safe, into her bedroom on a day before June 23rd. Is that right?
Sometime after the 9th of June, but before the 23rd, yes. The safe itself, however, apparently wasn't actually locked until the 23rd. Ms. Tracy indicated herself that it was open, although she never accessed it herself, and she apparently had some sort of PIN or code, but the safe wasn't actually closed until the 23rd.
Well, other than those 2 dates in June, is there any information in the record to indicate when the defendant went into the apartment?
Actual dates, no. Now, we know that he went there at various times during the summer, and I'm using that term rather loosely, because prior to the 9th of June, Alexis Tracy was pregnant. She actually delivered on June 9. He was there ostensibly to help her with whatever little chores or tasks, whatever might be needed to assist her with the pregnancy. But we don't actually know what dates we're talking about. For the purpose of the argument, we can assume that if he wasn't there every day, every other day, or various times during a week's period. But I can't tell you precisely what dates we're talking about.
But the only 2 dates that you're aware of, based on the record, when he took items there would be the dates we've already talked about. Is that correct?
We know that the safe was seized on June 23rd. We know that the drugs, the methamphetamine, was put into the safe the same day. The safe was actually placed in the apartment sometime after the 9th of June. So we're talking, and again, I can't tell you precisely when the safe went into the room, but we're talking about 2 weeks or less.
But there were 2 occasions when he put things in the apartment, correct?
Correct.
Okay. And then there were other occasions when he didn't necessarily put things in the apartment, but he was physically there, among other things, helping the renter, correct?
That would be correct.
All right, thank you.
Why does that length of time really matter if we're talking a social guest? As long as you can establish that you are a guest, that you have access to the apartment, and been given permission by the owner to leave your property there, even if it's for an overnight, isn't that enough under the case law?
Under the case law, well, in some cases, yes, it is. But other cases, well, all the cases that I have reviewed tell me that while that's something to be considered, that's not the entire argument. Our defendant never spent a night overnight at the apartment, so that takes him out of the purview of a case like State versus Olson. So the Court of Appeals was correct about this. Somewhere between no rights, absolutely not, and Olson, yes, you have an absolute right. Mr. Dannenbaum falls in between. The Court of Appeals reasoned that although there were contacts and apparently some sort of, I don't know, family feeling, brother, sister feeling, whatever, that did not rise to the occasion of allowing standing to overcome the search because they believed his absence on the date in question was the deciding factor in all of the factors that they considered. Mr. Anderson's correct about one thing. Not all the facts that were in the Court of Appeals opinion were the facts related to them by the briefs by both parties in the case. But they looked at the totality and focused on those ones that they believed helped make the case.
How can you say they looked at the totality if they didn't if they didn't consider all those facts?
I'm sorry?
How can you say they considered the totality if they omitted certain facts from their consideration?
I don't have the right to say that they didn't. What I know is what I saw in the opinion. This is what they believed to be important, or this is what they took into consideration when they made their final ruling. But I can't say that they didn't consider everything.
You're just saying they explicitly stated that these were influential, not that they failed to consider what wasn't included.
I never saw that in their opinion. They never said, we totally cast these aside because we're not going to even think about them.
Do we have any further questions? Does that conclude your presentation?
It does, sir. Mr. Justice, Justices, thank you very much.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you, Your Honor.
Just, counsel mentioned that that your client had permission to be there, but it was be in the apartment, but it was conditioned on the owner's, Ms. Tracy's, presence. Does that change the calculus at all in terms of the status of social guest?
Well,
Is that accurate? That
First-
presence was required in this kind of understanding of when he was permitted to be there?
first, specifically to the overall question of whether that would change the calculus, I think it would. However, in our particular case, that's just not the facts that were before the court. He was there on multiple occasions without her being there. As on the 26th of June, the day that these drugs were to be delivered by my client in the blue cooler, she left him there. And that is in the facts, in all the testimony. He was there on numerous occasions, according to Miss Tracy, without her. The question was
he able to enter without her being there?
if the door was unlocked. Yes, there was never any positive information that he had a key and had access if she secured her house. That I would readily admit. However, she never stated that he didn't. That she was certain he didn't have a key, but both my client and Miss Tracy testified that they didn't believe he had a key. So I'm not really willing to try to expound that argument to say, oh, because they couldn't say he didn't have a key, that he maybe had a key. I think that's a nuance not to waste the court's time.
Counsel, how would a court ever know or be able to determine that someone who at one point was a social guest has ceased to be a social guest? It seems to me the Court of Appeals used presence as kind of a proxy for that really sort of hard question to answer. Because, I mean, we all know we have social guests in our homes, and no one thinks that they're going to have a perpetual sort of guest status. They leave.
That's an interesting question, Your Honor, and I think I can answer. Maybe I'm off the cuff here or off the point, but I think I can answer that very easily with a case that was signed by the 10th Circuit on the 4th of April of 2017, I believe. U.S. v. Gilliam, 274 F sub 3D 1209, which Mr. Gilliam was a social guest of his sister. He had been staying at her house overnight for a couple weeks consecutively. She's on parole, finds out he has a warrant out, she kicks him out. He has nowhere to go, sleeps in the driveway that night. As she's leaving for work, she sees him there, sleeping in his van in the driveway. He calls her, says, "Hey, can I, go in, shower, charge my phone, make some arrangements so I can get out of your hair?" She said, "Yeah, that's fine." He goes in. Whatever happens with law enforcement, they come in and search while he had fallen asleep on the couch. Come in and search, and the 10th Circuit found that even though she had revoked his privilege as a overnight guest the night before, but allowed him to come back to clean up and whatnot, she had emphatically revoked his ability to be an overnight guest there. The day before, they said that he still had standing to object to the search. I mean, ultimately, the case was decided that she unequivocally gave consent to search the house. But the standing issue was addressed in that case very well, which I thought was relevant in general.
I can understand. I mean, in that, as you described it, the owner invited the person back into the home. I don't want to belabor the point, but just these are so fact intensive, this social guest spectrum that we're on. I'm just wanted to see if you had thoughts as to how a court would know when someone is a guest and when someone isn't. And it sounds like maybe there's not a good way. It's just really fact intensive.
Yeah, I would agree with you, Your Honor, and that was the one thing that I wanted to the rebuttal state was some of the factors we hadn't discussed. That Miss Tracy looked at my client as a brother. He was there daily, taking care of her, make sure she didn't need anything during her pregnancy and after she had the baby. The entire summer. There was testimony from both Miss Tracy and my client, as I just stated a little bit ago, that he was there on multiple occasions without her being present and was allowed to leave, stay for whatever and then leave. Specifically on that incident, the date of this incident, she left him there alone after he had shown up with the cooler. I am not going to stand here and make a big deal out of it because I'm not 100% certain, but I believe the argument just previously made by counsel that the duffel bag was brought that day on the incident date as well as the cooler. I don't believe that to be true. I believe that his clothes had been there for the majority of the summer. And then kind of the final point I wanted to make that you all asked Mr. Matthews as he was finishing up was how can he say that the Court of Appeals looked at the totality of the circumstance of the facts of this matter when they omitted some facts? And I believe Mr. Matthews had a very good response to that, in the fact that just because they didn't speak about some of the facts that I complain about and Mr. O'Donnell complains about doesn't mean that they didn't consider them, and I certainly understand that. But my issue is when you look at this, his stand in the totality of circumstances, yet your summation, you're the Court of Appeals summation, is in the last paragraph, there was two things they talked about. He wasn't present, and he didn't show a reasonable expectation of privacy. The entire opinion had everything to do about his actual presence. So I don't know how you talk about totality of the circumstances and all the facts involved, and the opinion is just littered with his lack of presence on that day. That is one factor. That's obviously not the totality. It's just one factor, and that was kind of the focal point of Mr. Donnebaum's petition for review.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning.
Justice, thank you very much.
Court will take this matter under advisement. This time